Therefore, a bill may also be made in favor of any institution. However, the institution should not have been set up to promote the anti-Islamic activity or promote any active Islamic campaign. It should not be an institution that promotes the religion other than Islam. A bill made in favor of Hindu temple or society is also invalid. But an institution engaged actively in promoting charity or public benefit is a competent legatee according to Muslim law. A society or institution engaged in promoting education and self-reliance among poor, taking care of leprosy and AIDS patients, for example, looking after orphans or old persons would be competent legatee. Muslim law cannot make a valid request. A Muslim cannot make a valid request in favor of another for building a church or for Jewish or synagogue or Hindu shrine. The general rule is that the legatee should be capable of holding the property. Means he should be in existence on the date of making the will. So, the effective date is the date on which the will is declared or executed and not the date of operation of the will or the date of the death of the testator. But a rule is that the legatee should be at the time of the making the will, and he should also be at the time of death of the testator. In both the situation, will be invalid if he is not, because on the date of the death, on the date of making the will, the testator must be capable of holding the property, and one will be regarded capable of holding the property if one is in existence. At the same time, in order to claim the legacy, the legatee must be in existence on the date of the death of the testator, otherwise the legacy will lapse according to the Hanafi law. But according to Shia law, if there is a legatee has died before the testator, legacy will pass on to the legal heirs of the legatee. But as a general rule, it is must for a legatee, it is must that he must be in existence on the date on which wasiyat is being made, either by oral declaration or in writing by executing a writing. Therefore, on the death of the testator, availability of the legatee may and may not be. According to Sunni law, it must be, he must be, or according to Shia law, he must not be, or it must not be. So, the rule which is applicable to a biological person, same rule is applicable to the artificial person or juristic person. For example, if the wasiyat is made in the name of any institution, school or college, hospital, and hospital was no more in existence on the date of the making of the will, wasiyat will not be, because rule is that legatee must be in existence. And now a very natural question arises: what will happen when a child is in the womb of the mother, means unborn child? Suppose X is a testator, owner of the property. He is making a will in the name of a child who is likely to born. He is in the womb of the mother, that is H. H is in the womb of the mother. It is known to the X that there is a lady in his relation. She is pregnant, likely to deliver a child after few months. He makes a will declaring that the child likely to born from a woman W, who will be the, say for example, H. So he will be the beneficiary under the will. Now here on the date of declaration of the will, legatee H, who is likely to born from W, is no more in existence. According to Sunni law and Shia law both, such will on the face of record will be invalid because rule requires that legatee should be capable of holding the property, and for being capable of holding the property, it is necessary that legatee whosoever is must be available or must be in existence on the date on which the wasiyat is made. But here there is an exception. An exception is that if the legatee is an unborn child and he is born within 6 months according to Sunni law, or within the 10 months under Shia law, such person by fiction of law will be deemed to have been in existence on the date on which the wasiyat was made. So from the date of wasiyat, making of the wasiyat, within next 6 months or 10 months, as the case may be, if child is born, such child shall be deemed to have been in existence on the date of making of the will, and in such circumstance, the legatee will be deemed to be competent to take the bequest or to hold the property to be given by means of the bequest to him or her. But if legatee was in existence on the date of making of the will, and he continues to be so for a longer period, but before the death of the testator, legatee dies, then according to Sunni law, such legacy will lapse and will not be given effect. Means it will not devolve the interest of the legatee, deceased legatee will not be allowed to devolve upon his legal heirs. But under Sunni law, availability of the legatee on the date of the death, that is on the date when the will be given, the effect will be operated, is not necessary, because rule is that if he has already died, his interest in the bequeathed property will pass on to the legal heir or heirs of the Shia legatee. This is the basic difference between Sunni law and Shia law on the point of the competency of the law. Anyhow, rule is that legatee must be in existence at least on the date of making of the will. A purpose of making will may be to benefit a specific individual or individuals, those who because of disability or poverty need financial help. The purpose can also be to obtain religious merit or to propagate the one's religion or religious belief. A will made in furtherance of religious, charitable or pious purpose is valid, but purpose should not be against that. Means will can be made with any motive is not important. Motive behind the will is of least importance. It may be for any purpose. For example, A is owner of the property and he is making the will in favor of the H, H is otherwise competent, though he may be a rich person. So richness of the person and financial status of the legatee is immaterial. Legatee may be rich or legatee may be poor. It is immaterial. What is material? That he must be available and should fulfill the other conditions, that is, that legatee should not be a legal heir of the testator. Legatee may be any person, may be male, may be female, may be Hindu, may be Muslim, may be institution, may be school, may be colleges. What is necessary? That he must be in existence. And the next requirement, and if he was not in existence, he was in the womb of the mother, must have born within 6 months according to Sunni law, or must have born within the 10 months according to the Shia law. According to some other schools, even child may take the birth within 2 years, even then he shall be deemed to have been in existence or capable of holding the property. This is one requirement. Legatee may be any institution, juristic person, I have already given the example. But what is the required? What is required? That it or he must be in existence. Second condition is that status of motive behind the will is immaterial. It may be religious, it may be even secular, may be without any motive, just in order to enrich the other legatee, one can make the bequest of his certain part of the property. So, financial condition or status of the legatee is not this. What is necessary? That legatee, whosoever is beneficiary or legatee under a will, should not be legal heir of the deceased. Means, on the date of the death of the testator, he should not be a legal heir person entitled to inherit his or her property or the property of the testator. Say for example, A makes a will in favor of his servant S. Now A is testator and S is the legatee. Rule is that legatee must be competent to take the bequest, means he must be capable of holding the property. Capable of holding the property means he must be in existence on the date when the wasiyat is made by A in the name of S. S may be any person, may be male, may be female, may be Hindu or may be Muslim. If he is Hindu, S is Hindu. What is required? That he must not be involved in any kind of the campaign which is hostile to the religion. Otherwise, a normal Hindu can also be a legatee under will in Muslim law. Further requirement is that motive behind the will in favor of the S is also immaterial. It may be religious or may be even non-religious. Even the wasiyat which is made in favor of the S by A, at the time of wasiyat, S may be in a good economic condition. Even then he can be, if he fulfill other conditions, he can be a legatee. But what is necessary? That at the time of making the will, on the date of the death, when the will be given effect after the death of the testator, so on the date of the death of the testator, when the will be given the effect, S should not be the legal heir of the A, means S should not be entitled to succeed the property of the A as a general law. Otherwise, motive is immaterial. Therefore, even if it is an institution, juristic person, maybe any institution, charitable institution or maybe religious institution, both are competent to be legatee provided other conditions are fulfilled by it. Guilty of causing the death of the means, if a legatee or beneficiary under the will is responsible for committing the murder or causing the death, intentional death of the testator, the will made in his favor would be invalid under Sunni law. It is irrespective of the fact that death might have been caused accidentally or intentionally. It is also immaterial whether he knew about him being a beneficiary under will or not. Under Shia law, the legatee will be incompetent to receive the benefit under a will if the death was caused intentionally. This is the difference between sine nulla and ciela. The time of making the will is of no consequence. It might have been made before the act causing the death of the testator, or it might have been made in between the time of committing the act which led to his death and the actual death of the testator. I have just pointed out that bequest is not allowed to be made in the name of heirs. That is, person legally entitled to succeed the property of the deceased relative. Therefore, an heir is a person who is competent to take the property of the deceased on his death in accordance with the rule of the inheritance applicable under the relevant law. The eligibility to succeed is to be seen at the time of the death of the testator and not at the time of making of the will. The reason is that because a will takes effect from the date of the death of the testator, in between the time of making the will and the death of the testator, the birth and death in the family may include or exclude potential heirs. Therefore, it will be seen as to whether the legatee in question is going to succeed the property of the deceased as his legal heir on his death. If it is so, then he will be not entitled to the bequest, and he will be disqualified to claim the bequest property or bequethed property. For example, I have already given a Muslim man having a wife, suppose H is a Muslim, he dies on, say for example, on 1/1/2021. On 1/1/2020, he made a will in the name of a person, say for example Z. H is testator, Z is legatee in the given example. Date of wasiyat is 1/1/20. Date of the death of the testator is 1/1/24. Means after 1 year of making the will, he died. On the death, he was survived by his widow, say for example W, his son H, his daughter D. Now here Z is also the brother of H. This Z is the brother of H. Now here friends, on the face of the record it appears that the brother Z may also be entitled to succeed in the property of the H, because he is the real brother of the H. She is the widow of the H, he is the son of the H, D is the daughter of the H, Z is the brother, D is the daughter, Z is the brother of the H. Now here S will exclude, here in this case on the death of the H. Now Z is claiming the bequethed amount of the legacy or bequest. Now here, will the Z be a qualified legatee or not? Rule is that legatee can be any person, provided on the date of the death of the testator he is not legal heir of the testator. Now here on the date of the death, decision will be taken who are the legal heirs. According to the rules of Muslim law, I have already discussed that brothers and sisters of all description are excluded by the agnatic male descendant of the deceased. Here S is the agnatic male descendant of the deceased. Therefore, S will be capable to exclude brother Z from the scheme of the inheritance, and he will not be entitled to take anything out of the property left by the deceased brother H. Therefore, here he can be a good legatee, Z can be a good legatee. If the will otherwise is valid, he will be entitled to be given or entitled to claim the bequeathed amount under the will made by H on 1/1/22, which is operated or will be operated after his death, that is on 1/1/2024. But suppose Z is another son of the H. This H has died leaving behind his widow, his one son, and other son is the Z. Now he has died leaving behind two sons, one daughter. Now that bequest was made by H in the name of one of his son, that is the Z. Z is disqualified, is not capable, is not a lawful legatee, because he is the legal heir of the H. Therefore, he cannot be a legatee under the given circumstance, because the rule is that no bequest in the name of legal heir. Friends, therefore, under Sunni law, a bequest cannot be made to an heir at all, and not even to the extent of 1/3 of the property. However, where the bequest is found in the name of the legal heir of the testator after his death, it can be validated by obtaining the consent of the other heirs. For example, H has died leaving behind S1, S2, D1, D2, and there is a widow. Bequest is made in the name of the widow. So, widow is legally entitled to succeed the property as she is the legal heir. Therefore, prima facie she is disqualified here, and bequest made in the name of the widow will be invalid, cannot be operated. But before disqualifying her, consent of the other heirs, that is of the son 1, son 2, the D1 and D2 will be obtained. If all of them give their consent, bequest even in the name of the heir, that is the widow, will be valid. However, if the sons give their consent but daughters withhold it, then to the extent of their share, will be effective and rest will be disregarded. So, if it is in the name of the heir, consent will be obtained. If consent is given, well and good. If not given, then the will become invalid. This rule that no bequest in the name of heir is based basically on a specific saying of the Holy Prophet, and it is written in the authoritative books on the subject that in his last sermon, the Holy Prophet declared reportedly that his statement that no bequest in the name of heirs. So, pursuant to this ruling of the Holy Prophet, a declaration of the Holy Prophet, all the Muslim jurists agree that bequest as such in the name of legal heir is not lawful. However, it can be made lawful by obtaining the consent of the other heirs. If the other heir gives the consent, will be valid. However, under Sunni law position is little, Shia law position is a little bit different. Shia law says that where will has been made by the testator in the name of legal heir, but it is within the limit of 1/3 of the net property, wasiyat will be valid even in favor of the legal heir, though it is against the general rule. And there are reasons why the legal heirs are not allowed to be legatee. Because there is a possibility of disturbing the scheme of the inheritance if the legatees are allowed, if the heirs are allowed to be the legatee also. There is a very deep social philosophy behind the rule that heir cannot be a legatee. And rule is very rational, just and fair on the face of the record and in actuality also. Reason and this can also lead to the family feud. An entire family can be disturbed because of this, and therefore the rule that one cannot be enriched at the cost of the other find full expression in this rule. Here friends, if the will is in favor of the legal heirs, as a general rule it is invalid, unlawful, but it can be made lawful by obtaining the consent. However, the consent must be valid consent, and it must be expressed or implied. It may be oral or it may be, but it should be valid. Valid here means that consent of the other legal heirs for validating the will in the name of other heirs, legatee, who is here, it is necessary that it must be without any inducement, means it must be a free consent. It must be expressed freely, without inducement, threat, promise, or etc. etc. Where will is executed in writing and is attested by testator's heirs, it is sufficient proof of the heirs consenting to act of testator. Similarly, where the testator makes a bequest in favor of an heir and at his death, the other heirs help the legatee in effecting the bequest. So, means the consent is necessary. Consent may be expressed or implied, but it must be a free consent. Once consent is given, it will remain valid forever. Under Shia law, the consent of the heirs whose share has affidavit can be given before or after the death of the, but under Sunni law, consent must be expressly given, but it should be given after the death of the, if it was given in the lifetime of the testator will be immaterial, but under Sunni Shia law, consent could have been given by the other testator in the lifetime of the testator or after the death of the testator, both are valid. Consent of 1 year or all, even all years. Legacy in favor of an heir can be validated by obtaining the consent of the one or some heirs or even all of the heirs, them collectively. Where all heirs give their consent, legacy is valid to the extent of the shares of all. Where only one or some of them give their consent, the legacy would be valid only to the extent of consenting heirs' share. Legacy in favor of heirs' total properties. Yalla legacy can be given to an heir to the extent of only 1/3 of the property of the testator. Under Sunni law, even to the extent of 1/3, heirs must give the consent, but where the legacy exceeds the bequatable 1/3, then it will not be valid even under Shia law unless that other heirs give their consent. Such a bequest would be valid then. However, even consent of the heirs cannot validate the bequest where only one heir has given the entire property to the complete exclusion of all others. Very clear.